Thank you for watching this webinar presentation on the IEP Annual Review Meeting. My name is Stephanie Klitsch, and I am the Assistant Director of the Education Law Program at Council for Children's Rights. Please remember to complete the post-workshop survey after watching this webinar. Just to note that the information I'm providing today is for educational purposes and is not legal advice. Before I jump into the content for this webinar, I wanted to share a little information about the Education Law Program. The Education Law Program has four main focuses. First, through our Education Advocacy for Individual Family Service, we provide individual representations for students and their legal guardians in need of legal assistance regarding special education, Section 504 plans, and school discipline. Families interested in legal representation can contact our Get Help email address or call 704-943-9609 for assistance. Second, through our Education Navigation Service, we work with students involved in the juvenile court system in Mecklenburg County. The service addresses issues related to students' education rights by identifying current education issues and providing detailed recommendations for how to resolve those concerns. Referrals can be made through our ELP email address or by calling 704-943-9611. Third, we focus on systemic education issues. We cannot individually serve all students in our community who may need our services. Instead, we strategically elevate issues that can have a broader impact on students in the community. Lastly, we provide free community trainings on topics related to education advocacy. In addition to our First Wednesday series, we provide training to parent groups and community groups by request. Here is the agenda for the webinar. I will go over some preliminary information and then focus on our main topic, preparing for the IEP annual review meeting. First, I'll go over 3 quick notes. Then I'll give an overview of the different types of education interventions. Then I'll jump into an overview of special education, then an overview of IEP meetings. I'll do a detailed dive into the IEP document and the prior written notice. Lastly, I will discuss best practices for before and after IEP meetings. Before I get started, I wanted to go over a few terms that I'll use throughout the presentations. There are so many acronyms when we discuss special education and some different terms that mean the same thing. I want you to understand that students who receive special education have an Individualized Education Program, an IEP. They are also called exceptional children, EC. EC is a North Carolina specific term. Ultimately, when we are talking about EC services, IEP services, or special education, I'm talking about the same services and can use those terms interchangeably. The Special Education Decision Maker, or SEDM, is a term you will hear me use throughout this presentation. I'm going to use it instead of the term parent, and let me explain why. SEDM is an umbrella term that incorporates all of the different individuals that might be making the special education decisions for a student. For the majority of students, it's their biological or adoptive parents. For others, though, it is more complicated. For students that live with non-parent legal guardians or are in the foster care system, the SEDM might not be their parent. Other options include non-therapeutic foster parents, former guardians, kinship placements, district-assigned surrogate parents, or court-appointed special education decision makers. SEDM is the person legally acting as the student's parent for purposes of special education decisions. This is the individual who requests an EC evaluation, consents to EC services, and has the right to pursue dispute resolution strategies. So while for most students, their SEDM will be their parent, I'm going to use the term SEDM to be inclusive of all possible individuals who might be making special education decisions on behalf of students. Our last of the 3 quick notes is about charter schools. Some families choose to send their students to charter schools instead of a typical public school district. Charter schools are public schools authorized by the State Board of Education and are operated by independent nonprofit boards of directors. Everything that I will discuss in this webinar applies to charter schools as well as traditional public school districts. Charter schools must follow special education law, Section 504 law, and North Carolina law on school discipline. Too often we learn of situations where charter schools are telling families that they do not need to comply with these laws. So we want to make it clear that students have the same rights in charter schools as they do in traditional public school districts. Next, I'm going to do a brief overview of the different types of education interventions. We like to begin trainings with these slides so that everyone is aware of what we mean when we talk about terms like IEP and Section 504 plan. This graphic helps us take a step back and understand what types of services are available to different groups of students. The largest circle incorporates all students, whether or not they have a disability. Any student who is struggling academically or behaviorally in school can receive extra assistance. In North Carolina, this is through something called Multi-Tiered System of Support, or MTSS. You do not need a disability in order to receive support through MTSS. In order to fall into either of the 2 smaller circles, a student must have a qualifying disability. The bigger of the 2 circles is Section 504. As you will learn, more students with disabilities fall under Section 504 than under special education. Special education is the smallest circle because it has the most stringent eligibility requirements. As I mentioned, MTSS is available to any student, whether or not they have a disability. It is intended to provide extra support and interventions to students with additional needs. MTSS involves different tiers of support. All students are considered starting on Tier 1 and have access to high quality instruction. At Tier 2, students with identified academic or behavioral needs receive some small group intervention. Tier 3 is the highest tier of MTSS. At this tier, students receive more intensive individualized supports. A key component of MTSS is universal screening. This is intended to identify students who need supplemental support. By the time students get to Tier 3, they should be receiving evidence-based interventions to respond to their specific needs. Progress monitoring is a part of MTSS as well. This means that there are specific goals that the interventions are intended to address, and data is regularly collected to determine whether students are making progress toward those goals. Families need to be aware when their student is on a Tier 2 or Tier 3 plan and actively participate in the process. There are generally meetings to review the student's progress, and the family should attend and ask to get regular updates based on the progress monitoring. The MTSS team can make a referral to special education if they believe that the student may qualify for an IEP. This referral can happen concurrent with the MTSS intervention and need not wait until those interventions have been exhausted. Let's talk briefly now about who qualifies for special education services, which was the smallest circle in that first graphic. For a student to receive special education services, the student must meet all of the following criteria. Be between the ages of 3 and 21. Meet the criteria for at least one of 14 disability eligibility categories. In North Carolina, each eligibility category has specific requirements that must be shown for the student to fall under that category. For instance, a diagnosis of autism by itself does not necessarily mean that a student will automatically be eligible under the autism eligibility category. They must also have a disability that adversely affects their educational performance and requires specially designed instruction. I want to point out that educational performance is broader than academic performance. A student can be advancing from grade to grade and have passing scores in their classes and still be eligible. Educational performance also includes things like their social interaction and their behavioral needs. Here is a list of all 14 disability eligibility categories in North Carolina. IEP stands for Individualized Education Program. The P in IEP stands for program and not plan. And that is because an IEP incorporates all of the special education services that a student receives, making it a real program. The IEP document itself is long, generally at least 15 pages, and is very detailed. Included in the IEP document are the student's strengths, weaknesses, and needs, measurable goals for the student to achieve in the course of a year, the accommodations, modifications, related services, and specially designed instruction necessary to help the student reach those IEP goals, and where the services will be provided. This does not mean the actual location, such as at Myers Park High School versus West Charlotte High School. Instead, this refers to whether the student will receive the services with their non-disabled peers, or instead in a setting with only other students with disabilities. For many students, it ends up being a combination of those options. The IEP document is developed by an IEP team, which must include the special education decision maker. All special education students are entitled to something called a free appropriate public education, FAPE. FAPE is a legal standard that requires all students' IEPs to be sufficient for the student to achieve reasonable educational progress. We often receive questions about the difference between IEPs and Section 504 plans. As I have said, all students who receive special education services have an IEP. Students with IEPs receive some amount of specially designed instruction with a special education teacher. Specially designed instruction is adapting the content, the methodology, or the delivery of instruction to meet the unique needs of a student that results from the student's disability. Section 504 accommodation plans, however, are for students with disabilities whose needs do not rise to the level of requiring specially designed instruction from a special education teacher. These students receive all of their instruction in a general education environment. They receive accommodations and modifications that their general education teacher can implement to allow the student to have access to their education. Also, Section 504 has a broader definition of disability. So more students qualify under Section 504 than qualify for special education. This is why the Section 504 circle in the first graphic was bigger than the special education circle. If a student has an IEP, they don't require a Section 504 plan because everything that would be on the Section 504 plan would be incorporated into the IEP. Hopefully, an example will help illustrate the difference between an IEP and a Section 504 plan. Sam meets eligibility criteria as a student with a specific learning disability. His IEP provides services with a special education teacher several times a week to address his individual goals in reading, writing, math, and organization. He also receives modified assignments, extended time on tests, and takes tests in a room with fewer students. On the other hand, Aaron has severe myopia, which is nearsightedness. Her Section 504 plan requires seating near the teacher and board, and all printed materials presented in a larger font. As you can see, Aaron does not have any special education services or any individual goals like Sam has. Also, Sam receives accommodations and modifications that, if those were all he needed, could be on a Section 504 plan. Those accommodations and modifications are modified assignments, extended time on tests, and taking tests in a separate setting. Here are some important similarities between IEPs and Section 504 plans. They both generally have review meetings every year. IEPs are required to be reviewed annually, and while that requirement is not in the law for Section 504 plans, it is a common practice for them to be reviewed annually as well. These are very important meetings for families to attend. While there is only one meeting required each year, families can request an IEP meeting or Section 504 meeting at any time during the school year. Lastly, IEP teams and Section 504 teams can spend hours and hours drafting a beautiful document, but if it's not actually implemented, then it's worthless. It's critical for families to follow up with the teachers to make sure that the services, accommodations, and modifications are actually being provided as written. The remainder of the webinar will focus on special education generally and what to expect from the IEP annual review meeting process. I wanted to begin by sharing briefly about some of the major tenets of the federal law governing special education services, the Individuals with Disabilities Education Act, known as IDEA. It was originally passed under another name in 1975 and has been reauthorized several times. Under IDEA, each state gets some federal money to help provide special education to students with disabilities. In exchange for the money, schools must follow the requirements of IDEA. During our trainings, we rarely spend time reviewing the actual language of the law, but this is one of our few exceptions. It says that all children with disabilities have available to them a free, appropriate public education that emphasizes special education and related services designed to meet their unique needs and prepare them for further education, employment, and independent living. I'll spend the next few slides defining the terms in this slide, including free, appropriate public education, special education, and related services. I like to read this powerful statement from the actual text of the law because it emphasizes the real purpose of the law, which is to make sure students are prepared for their future, specifically further education, employment, and independent living. The emphasis on these topics grows as the students age, but the IEP team should be thinking from the very beginning of the students' special education services about how to prepare them for adulthood. Hopefully this sounds non-controversial to everyone now, but it was not always the case. Historically, students with disabilities were excluded from school. We did not have a law in the books until 1975 with the Education of All Handicapped Children Act, and even that did not provide many substantive rights and only addressed a narrow group of students with disabilities. Around that time, North Carolina actually criminalized a parent's effort to enroll a student with severe disabilities over a school's decision to exclude them. So when the Education for All Handicapped Students Act, later renamed IDEA, arrived, it was a massive step towards accessibility and equality. IDEA guarantees a free, appropriate public education, a FAPE, in the least restrictive environment, LRE. These are necessarily subjective standards designed to lead to tailored solutions that address each student's unique needs. But as you can imagine, that also creates some gray area that gives rise to disagreement. What actually is appropriate? Or what actually is the least restrictive? I will review these terms in more detail now. Let's talk about FAPE a little bit more. FAPE means special education and related services that are free, appropriate, and public. First off, free means free. The SEDM does not pay for any services, nor are there any administrative fees that can pose a barrier to services. Appropriate is where you might see the most tension. The word appropriate in FAPE has been interpreted by the Supreme Court. The Supreme Court has not interpreted appropriate to mean that the school has to make the student the best student they can possibly be. There have been two Supreme Court cases to interpret this term. One was Rowley in 1982, and the other was Andrew F. in 2017. In Andrew F., the court said that a student's special education program must be appropriately ambitious in light of the student's circumstances. This is determined by the student's own circumstances, not the school's circumstances. We don't have the resources is not a valid basis for a denial of services. It is important for SEDMs and advocates to understand when in an IEP meeting, not to state that you are requesting services for the student because you think the student needs them to do the best that they can or to maximize potential. The school staff know that this is not what is required, and therefore they won't be moved to action by that. Instead, the SEDM should be making the case for what the student needs to make reasonable educational progress that is appropriately ambitious for them. Public education means that the services are supervised and directed by the local school system. Special education is specially designed instruction provided at no cost to SEDMs that meets the unique needs of the student. Specially designed instruction means adapting the content, methodology, or delivery of instruction. The unique needs of the student go beyond just academics, however, and may include social, emotional, physical, health, and vocational needs as well. Take, for instance, a student with a severe cognitive disability. Their specially designed instruction may include a focus on activities of daily living and social interaction, in addition to more traditional academic skills. Related services are those additional services necessary for a student to benefit from their special education. A very basic example is a student with some measure of hearing loss. If they cannot hear their specially designed instruction, they cannot feasibly benefit from it. So audiology services may be included as a related service and provide, among other things, a check-in once or twice a semester with a school audiologist to make sure their hearing device is working as intended. I've listed other common related services on the slide as well. The last concept I will cover is least restrictive environment, LRE. LRE means that students with disabilities shall be educated with students without disabilities to the maximum extent appropriate. This means that students will be placed somewhere along a continuum of placement options according to their unique needs. Consultation is the least restrictive, in which the special education teacher collaborates with the general education teacher on the student's instruction, but the special education teacher provides minimal, if any, direct instruction to the student. Inclusion classes, sometimes called co-taught classes, are classrooms where the general education teacher and a special education teacher work together to support the students. And the students remain in the general education setting, but receive support on their IEP goals from the special education teacher in the room. With resource or pull-out services, students are removed from their peers without disabilities and receive instruction in a separate classroom for some portion of the day. In separate classes, students spend the majority of their day apart from their peers without disabilities, though they remain in the same school and able to interact with the whole of the student body through other shared activities. Students in separate classes often still attend elective classes with their non-disabled peers. Separate schools are exactly what they sound like. Students' needs are significant enough to warrant placement in a more specialized school setting, wholly apart from their non-disabled peers. Lastly, we have home hospital instruction, the most restrictive, wherein the school provides one-on-one instruction directly to the student in their place of residence. This is supposed to be a temporary placement, and minimal hours of instruction are provided. Remember, placement anywhere along this continuum outside of the general education setting requires justification grounded in the student's individual needs. Other reasons, like availability of placement or administrative convenience, they're not valid justifications. I'm going to spend the next few minutes discussing who attends IEP meetings and how often they should happen. As I mentioned at the beginning, every student who receives special education services has an Individualized Education Program, or IEP. I'm about to review the components of the IEP in depth. The IEP is created by the student's IEP team. There are certain required members of the IEP team. This includes the Special Education Decision Maker, SEDM, a regular education teacher of the student's special education teacher, a representative from the local educational agency, or LEA. This is a representative of the school district who can make binding decisions about services and resources. Often this looks like a school administrator, such as the principal or assistant principal. If the IEP team will be reviewing evaluation results, then you also need somebody who can interpret the results of those evaluations and what the results mean in terms of instruction. Students begin to be invited to their IEP meetings once they turn 14. They are not required to attend at that time, but are required to be invited. They can also attend at a younger age if their SEDM wants them to attend. While these are the required members of the IEP team, the SEDM can invite others to join the meeting as well. The IEP annual review meeting happens once a year and is a thorough review and update of the entire IEP document. Reevaluations happen at least once every 3 years, but the SEDM can request a reevaluation before the 3-year mark. It's important to know that there cannot be any changes made to the IEP document without an IEP meeting. That includes any changes to the goals, accommodations, special education service time, or the special education placement. Outside of an IEP meeting, nothing about the IEP document should change. There are also generally IEP transition meetings. These happen in the spring before a student transitions from pre-K to elementary school, from elementary school to middle school, or from middle school to high school. These meetings help make sure that the IEP can be fully implemented in the next school for the first day of the new school year. When an IEP meeting is scheduled, the school district is required to give the SEDM reasonable notice of the meeting. The notice must be in writing and in the SEDM's native language. The law does not require a specific number of days for the notice before the meeting, but often districts have created internal policies that they try to follow, such as sending it out at least 7 days before the meeting. The document should state the purpose of the meeting and who will attend the meeting. It is important for SEDMs to pay attention to the invitation to conference. They should read, sign, and return it as soon as possible. Like with all school records, they should keep a copy of the document. When reviewing the document, look at who will be attending and their role. So SEDMs should think about who they may want to bring to the meeting. Sometimes it makes sense to see if one of the student's service providers can participate in the meeting, either in person or by phone. It is very important to look at the suggested date and time of the meeting on the invitation to conference. If it does not work for the SEDM, they should respond in writing with suggestions for other possible meeting dates. If there are others the SEDM is inviting, such as members of a child and family team, the SEDM should consult with their availability as well. When possible, I encourage SEDMs to jump on scheduling before even the invitation to conference is sent out. For instance, if I know that the student's annual review is due by October 10th, I would suggest reaching out to the school in mid-September to start discussing possible dates for the meeting. Ultimately, SEDM should also receive an invitation to conference before the meeting. Sometimes the EC case manager will send the document home with the student in their backpack, which is not a particularly reliable way to get it to the right person in a timely way. If a meeting is approaching and the SEDM has not yet received a copy of the invitation to conference, they should reach out proactively to the EC case manager and ask for it to be sent to them. This is a document that can be emailed if that's easiest, or sent by mail or fax. I'm now going to go through the IEP document in great detail. It is helpful to understand all of the parts of the IEP document. IEP teams tend to go through the IEP document in order. So this helps you understand when conversations about different topics related to your students' special education services will happen during the meeting. Throughout the slides, I will be sharing some screenshots from part of an example IEP from the North Carolina Department of Public Instruction, or DPI. This is also included in your materials for the session. Let's start with the information in the header of the document. There are a couple important areas to highlight here. It lists the student's eligibility category. If a student has more than one eligibility category, one will be labeled as the primary eligibility category and the other will be labeled as the secondary eligibility category. While the eligibility category is important to know, it is equally important to understand that this category in no way limits what services are actually available to the student. Services are tailored to a student's specific needs, and different students may have different needs arising from the same disability. The header also lists the purpose of the meeting. When it is the yearly review meeting that occurs, it will be listed as the annual review meeting. The next area to highlight is the dates that the IEP will be in effect. It normally is implemented a few days after the meeting and can last an entire year. So the IEP team could always choose a shorter time frame if that is appropriate for the student situation. It sometimes comes as a surprise to SEDMs that soon after the meeting starts, the IEP team will look at the parent for their input on the student's strengths, their own concerns, and a vision for the student's future. For strengths, this field is often pre-filled by the school, but it should reflect input from everyone. If you have something to add, make sure to get it written down. Concerns and vision. These two fields belong to the SEDM and student. The school has no say in what is included here. Often, you may see the concerns or vision simply copied from previous IEPs, but they should always reflect the most current information and perspectives. For the vision, it is important to remember the student's input. If the student does not attend the meeting, their perspective should be gathered beforehand. If the student is attending, it is a good place to encourage their active participation to the extent they are willing and able. I strongly recommend that before the IEP meeting, the SEDM write out their concerns and vision for the student. The SEDM can email these to the EC case manager to copy and paste directly into the document. The present levels of academic and functional performance form the basis for the annual goals in the IEP. As I will explain in more detail in a few minutes, the annual goals are critical in determining what special education and related services a student receives. The present levels should summarize all data collected from screening tools, test scores, grade level assessments, and observations. They should describe what the student can do in each area and areas where the student needs to improve. There should be a present level for each area of ongoing concern, including academic performance in reading, writing, and math, functional performance, including skills like communication, organization, and daily living skills, behavior, social and emotional development, and related services. The present levels must be specific and objective. Here's an example of a present level of performance from the DPI example IEP. It states, based on informal writing assessments, Henry is able to write complete sentences with correct beginning capitalization and ending punctuation with 80% accuracy when given assistance. Using a graphic organizer or model, he can generate sentences featuring supporting details that he is able to brainstorm independently. However, Henry has demonstrated an inability to write introductory or concluding sentences to allow his thoughts to transition smoothly between paragraphs. When writing assignments require a multiple paragraph response, this lack of transition makes it difficult to follow Henry's train of thought and reasoning. On the last 3 essay responses of 3 paragraphs or more, Henry earned an average of 63% accuracy as measured by a writing rubric. This example has a lot of detailed information about Henry's writing skills. We now understand that he is able to use capitalization and punctuation consistently, and is also able to write sentences with supporting details. When the present level moves into areas where Henry struggles, I start making note of what annual goals I should see in writing for him. Here, it looks like he needs an annual goal around transition sentences, including introductory and concluding sentences. IDEA requires IEP teams to consider a series of questions that they refer to as special factors. If the answer to any of the questions is yes, then that factor must be addressed in the IEP. As you can see from the sample, in the consideration of special factor section, it also states where the special factor is addressed in the IEP. This is the entire list of questions in the consideration of special factors section. It covers the following topics: English language learners, students with special communication needs, students that require assistive technology, students who use Braille, students with documented hearing loss, students with behaviors that impede their learning or that of others, students who require adaptive physical education, students who receive instruction using the extended content standards. The extended content standards are intended to serve students with significant cognitive disabilities. In North Carolina, these students may earn a graduation certificate, but not a traditional diploma. Under the behavior special factor, I note that a student's behavior can be addressed through behavior goals with associated special education time, and/or a functional behavior assessment, FBA, and behavioral intervention plan, BIP. If a student is having behavior issues, it is important that this is noted in this section. When I reviewed the purpose of IDEA earlier, I stated that it was for students to receive special education and related services to prepare them for further education, employment, and independent living. Transition plans are the main way that this tenet of IDEA plays out in the IEP document. They address life for a student after high school, detailing goals for education, employment, and independent living. The requirements in this section grow as the student ages. By age 14, there must be a statement of the student's needs, preferences, interests, and courses of the student. One very important aspect of transition planning is the decision about whether the student is preparing for additional education, such as college or other vocational program, or employment or independent living that does not require additional education. This decision will direct the high school course of study. By age 16, there must be measurable post-secondary goals based upon age-appropriate transition assessments related to training, education, employment, and independent living skills, and transition services needed to assist the student in reaching those goals. Students themselves, along with their families, are in a particularly good position to make sure the plan focuses on what skills the student needs beyond what he is getting in high school classes to be successful after high school. It could be a work experience, or learning how to manage money independently, use public transportation, or being prepared to move from the student's current home. The plan and the activity should be coordinated and sequenced so that the student is ready for the next step when high school ends. Transition plans should be described with the same specificity as a student's specially designed instruction. When do the services start? How often will they be delivered? Where will they be delivered, and how long will they last? The IEP team does not need to wait until a student is 16 to include these services in their IEP. Students that have significant needs or are at risk of dropping out could certainly use this planning sooner. Not all of the activities must be provided by the school staff. School staff can coordinate with other community agencies, such as vocational rehabilitation, driver's education, and others to provide services. It is not lawful for the IEP to identify the SEDM and the student as the only responsible persons to implement the transition goals. School staff must supervise and coordinate services provided by other agencies or the parents. Representatives of other agencies, such as the VR agency, Vocational Rehabilitation, can be invited to participate at IEP team meetings in which transition services and post-secondary goals are discussed, if that agency is likely to be responsible for providing or paying for the transition services to be included in the student's IEP. However, IDEA requires the consent of the special education decision maker. Annual goals must address the concerns identified in the present levels, which again underscores how important, accurate, and thorough present levels are. Goals are developed so that students should be able to successfully accomplish them within 1 year from the IEP start date. It is critical for the IEP goals to be specific and measurable. Goals should be appropriately ambitious in light of the student's circumstances. Appropriately ambitious. What does this mean? Well, the student's circumstances will decide that. And note is written right there, but annual goals can easily become a cookie cutter nightmare, especially if the student has a lot of them. Each goal should be tailored to the student at that moment in time, and not just remix versions of old goals that may no longer be relevant or copied and pasted from a goal bank because that's how the school addressed a similar need in the past. The IEP goal must include how progress on the goal will be measured. Whenever possible, you want these to be objective measurements, such as scores on assessments. SMART IEP goals. This acronym is often used as an easy way to describe what good IEP goals look like. S is for specific, M is for measurable, A is for use action words, R is realistic and relevant, and T is time limited. With IEP goals, you want to strike the right balance so that the school is making real progress over the course of the year. You don't want the goal to be so easy that the student accomplishes it within a few months. You also don't want the goal to be so challenging that it takes longer than a year for the student to achieve it, assuming the student is receiving appropriate specially designed instruction in the goal area. Here are a couple goals from the example IEP from DPI. The first goal is, given a reading passage at his instructional level, Henry will read 105 words or more per minute in 4 out of 5 trials with 100% accuracy. It states that the goal will be measured with running records, data sheets, and anecdotal records. The second goal is, Henry will decode 2-syllable words with long vowels, digraphs, prefixes, and suffixes on a curriculum-based measure at a beginning 3rd grade level and 3 consecutive curriculum-based measurements. This goal will be measured with data sheets and informal assessments. These would both be considered SMART goals. They are specific. One is for reading fluency and the other is about decoding. They are both measurable and detail how they will be measured. They use action words, including read and decode. It is hard for us to judge how realistic they are without analyzing the associated present level and other parts of his IEP, but they seem like critical skills for students with their reading development. And time limited, I assume that these goals are meant to be achieved over the next year for Henry. Let's move on to placement in the LRE statement. I discussed the concept of the least restrictive environment, or LRE, earlier. The IEP document addresses this in the placement section. This details the setting in which the specially designed instruction will be delivered. If a student is removed from their non-disabled peers at any time during the day, an LRE justification statement is required. This should explain why the student cannot receive the services in a setting with their non-disabled peers. There must be specially designed instruction to address each IEP annual goal. The IEP team must detail the amount of instruction needed to make reasonable progress toward the goals. The IEP must state the type of specially designed instruction that will be provided, the frequency and duration of the services, and the location, whether it will be provided in a special education setting without non-disabled peers or a general education setting that includes non-disabled peers. It's important to understand what these services look like in practice, not just on paper. If the student receives their specially designed instruction in a general education classroom, is it provided by co-teaching, where the regular education and special education teachers share responsibility for providing instruction to the whole class? Or is it something like collaborative instruction, wherein the special education teacher works directly with their students within the general education setting, but typically for less than the full length of the class? This level of detail will not be provided on the IEP document itself. So it's important for SEDMs to ask questions to better understand what services will look like for the student. I discussed related services earlier. These services are also detailed on the IEP document and must show the frequency and duration of the services. Related services should either be integrated with the student's goals or have specific goals written for those services. Some examples of related services are interpreting services, occupational therapy, counseling services, and parent counseling and training. I have included here what Henry's specially designed instruction and related services look like on his IEP. It shows that he is receiving specially designed instruction in 4 areas: reading, math, writing, and behavior. It shows how long each session is and how frequent they are. It also shows that he receives pull-out services for reading and math in a special education setting, but his writing and behavior services happen in the general education environment. Henry also receives speech language services 1 time per week for 30 minutes in a special education environment. It indicates that he has a speech language goal. The next section of the IEP document I will discuss are accommodations and modifications. Accommodations change how information is presented to a student, whereas modifications change what the student is expected to learn. I often describe accommodations as leveling the playing field for students with disabilities. Some examples of accommodations include preferential seating, extended time on tests or assignments, dictation to scribes, study guides, and read aloud. There are many lists of possible accommodations that you can view on the internet to get ideas. It is helpful to understand that the same accommodation can frequently be used to address different needs. Preferential seating could be great for a student that needs to be closer to the board to read, but it could be equally beneficial to a student with behavioral challenges that benefits from sitting closer to the teacher. Occupational course of study is a modified curriculum. It is intended to prepare students for graduation into competitive employment, but does not meet the credit requirements for entry into a typical 4-year college program. The extended content standards that I mentioned previously are another example of a modified curriculum. Students with IEPs may require testing accommodations. Some examples include testing in a separate room, marking answers in the test booklet, multiple testing sessions, read aloud, and scheduled extended time. It's important to make sure that these accommodations actually have the desired impact. I had a student that historically benefited from separate testing, but began to have an intense emotional response to being removed from her peers. Was the benefit of the accommodation worth the emotional ringer it put her through every test? Could the school have shown some more sensitivity in how they provided the accommodation? These are questions worth asking. The last area of the IEP document I'll discuss is extended school year, or ESY. At each IEP meeting, the IEP team must address the need for ESY services. ESY services are special education services provided at no cost to parents during the summer or other school vacations. They're provided to a subset of special education students who need those extended services to get a FAPE. Although some special educators may say so, nothing in the law limits ESY to very low functioning students who need work on daily living skills. ESY can be focused on academic, functional, behavioral, or other skills. The services provided will vary considerably based on the individual student's needs. Special education teachers should be keeping data on students so that the team has the information it needs to decide if a student meets the criteria for ESY. Back in the sample annual goal, you might have noticed a column titled Methods of Measuring Progress that included things like data sheets, informal assessments, running records, etc. This is the data you would want to ask for if you are considering whether ESY is necessary for your student. I'm going to spend a couple minutes talking about a very important form called the prior written notice. The prior written notice is the IEP form completed at the conclusion of an IEP meeting. It states what the IEP team agreed to, what was considered by the IEP team and rejected, and importantly, what was proposed by the SEDM and refused by the school team members. Having the information clear on the prior written notice is extremely helpful if the SEDM wants to pursue any dispute resolution strategies. Everything that occurred at the IEP meeting should be documented on the prior written notice form. If you don't agree with how something is stated on the PWN, let the team know what your concerns are and how you believe the information should be documented on the PWN. It is hard to overstate the importance of this document. As an advocate, I tend to read it before I review an IEP itself to better understand the context of the meeting and what parties might have desired or intended versus what actually made the final cut. Before you leave an IEP meeting, make sure you have read and agree with the PWN, and if you cannot get your desired edits in, have your objections to it written into the PWN itself. IEPs can be long and hard to parse at a glance, so the PWN becomes an important historical document that may play an outsized role in how future parties understand the student's needs. It is likely hard to read on this slide, but I've included a blank version of the prior written notice in your materials. On these 2 pages, the document asks for the actions proposed and the reasoning for the actions proposed, and then the actions refused and the reason for the actions being refused. When I am making a request in an IEP meeting, I often put my request in these terms to make it clear the gravity of what I'm suggesting. For example, I will say, I propose that the student receive speech language services as a related service. If the rest of the IEP team does not agree and can't seem to be swayed by my arguments, I will say that I want that included on the PWN as a refusal. It is important that they include their reasoning for the refusal, and the reasoning written on the form should be the same as the reasoning they gave you when you made the proposal during the meeting. On the 3rd page of the PWN, there's a place to include other options the IEP team discussed and why those options were rejected. A rejection is different here than a refusal. A rejection is an idea that the team discussed, but generally agreed was not needed or appropriate. For instance, let's say that the IEP team discussed whether the student needed extended time on tests, but then determined that she never uses all the testing time she is given. This would be something that the team proposed and then rejected. The refusal section on the previous slide is really reserved for items that the SEDM proposed, but were not agreed to by the IEP team. In our remaining time, I wanted to review some best practices for before and after IEP meetings. Preparation for IEP annual review meetings is critical. One of the main ways to prepare is to review your students' records, especially records since the last IEP meeting. As much as possible during an IEP meeting, you want to be able to point to data to support whatever you are requesting. Therefore, it's important to review school records, health and mental health records, and written communication with the school about your students' needs and progress. As you review the records, reflect on the following questions. What has your student accomplished? What has worked well? And in what areas does your student still struggle? I talked earlier about the parental concerns and the parent and student vision statements that are on the first page of the IEP. I strongly suggest that you draft these in advance and email them to the EC case manager. That way, those items can be copied and pasted directly into the IEP document, and you don't have to worry about being put on the spot at the start of the meeting. You can take your time to craft them rather than rely on the EC case manager to paraphrase your words during the meeting. I always ask for a draft of the IEP document to be emailed to me in advance of the meeting. I let the EC case manager know that the meeting will be much, much more efficient if I have a chance to review the draft in advance. They're not obligated to send it, and you may only get it the day before, but it's definitely worth asking. Once I have the draft, I review it side by side with the current IEP so I can understand what exactly the school is hoping to change. In advance of the meeting, talk to any professionals involved with the student and get their input. If possible, see if they can participate in the meeting. They can write a letter, participate by phone, or even attend in person. No matter the age of the student, it is a best practice to get the student's input before the meeting. If the student plans to attend, it's a good idea to prepare for them for what to expect. I come to IEP meetings with notes. I've thought about in advance my goals for the meeting, the questions I want to ask the team, and I've brainstormed any potential suggestions or interventions that may help my student. That helps me participate much more confidently in the meeting when I have all of that right there in front of me. Before the meeting ends, you want to review your list of questions and make sure you have asked them all and have received an answer. Be sure to know who is responsible for implementing the different parts of the IEP. Sometimes these meetings run much longer than anyone expected. If you run out of time before everything has been addressed, schedule another meeting while the IEP team is still gathered. Sign the IEP. Signing the IEP only indicates that you were present and not necessarily that you agree with the contents. Do not worry that signing the IEP will mean that you can't pursue dispute resolution strategies if necessary. Make sure you receive a copy of the IEP documents at the end of the meeting. If they will say that they will send them to you after, find out an exact time frame. You will be surprised how often I review the IEP documents after a meeting and find errors that were made during the meeting. I suggest taking a day or so after the meeting and then reviewing the documents closely. Make sure that you have received everything and follow up if any corrections need to be made. If the prior written notice did not fully capture your point of view, follow up with a letter or a detailed email and ask it to be included in your students' records. Share the IEP documents with any other involved parties as appropriate, such as tutors, counselors, and therapists. DPI has a webpage that is full of resources about North Carolina's online system for IEPs called ECATS. On this webpage, you will see training videos, a manual, tip sheets, frequently asked questions, and newsletters. These are primarily aimed at special education teachers and administrators, but may also be helpful to you if you have specific questions. I hope the information provided today has been helpful. If you believe you may need legal representation related to a Section 504, education, or school discipline issue, you can contact our team at gethelp@cfcrights.org or call us at 704-943-9609. For court-involved youth, members of the Child and Family Team or student's juvenile defense attorney can make a referral for our education navigation services by emailing elp@cfcrights.org or by calling 704-943-9611. For training requests, please contact us at elp@cfcrights.org or 704-372-7961. I've provided here some links to some helpful resources, including the NC policies governing services for children with disabilities. Also, please be sure to review the handouts for this webinar. Please remember to complete your post-workshop survey. It should only take a couple minutes and will provide us with feedback that we can use to improve our webinars and presentations. Thank you again for watching.